Thank you for supporting the National Coalition for Sexual Freedom and being interested in some of the best news we've ever been able to share with you. As you probably know, our Consent Counts project has succeeded in decriminalizing BDSM in the new Model Penal Code on sexual assault, which was approved in June of this year. NCSF has been working on this Consent Counts project for 14 years, so we're very glad about this big step forward in decriminalizing BDSM. This is groundbreaking because even today, people who engage in BDSM, even if it's consensual, may still be violating their current state law. That's why this change was so important. And that's why our next step is to lobby in each state to get the Model Penal Code on sexual assault adopted. We're going to go over the text of the new Model Penal Code on sexual assault, including the definitions of consent for sex and for BDSM, and explain our next steps. First, let's sum up the new legal framework that deals with consent to BDSM, and then we'll give you the background on the project and why it's important. The section titled Affirmative Defense of Explicit Prior Permission. You may personally give another person explicit prior permission to use or threaten to use physical force or restraint, or to inflict or threaten to inflict harm in connection with an act of sexual penetration, oral sex, or sexual contact. Whatever is done, it can't cause serious injury. You know the saying in the kink communities that we hurt and not harm? The spirit of that sentiment is carried on in this, because you're not allowed to seriously injure someone, which is well defined in law, and means things like the impairment of a limb or organ or a risk of death. So this provision where you can give another person explicit prior permission might not cover consent for edge play like breath play or employing compression around the neck, or bondage or suspension where severe nerve damage is done. It also wouldn't deal with BDSM interactions that don't include sexual contact. In this context, sexual contact means touching the buttocks or breast, closed or unclothed, or include oral, vaginal, or anal sex. In our last consent survey in 2021, 90% of the 3,000 respondents reported they do like some kind of sexual touch or penetration with kink activities. Also, things like spanking constitute sexual touch because it's touching the buttocks even when clothed. Based on that information, this provision will leave a lot of people more protected. When you break this down further, permission is defined as explicit under Section 10 when it is personally given verbally or in writing. Explicit prior permission does not mean using body language or past behavior to determine consent. You must talk about it first and come to an agreement. And even then, there are some caveats that need to be met. You have to specify when someone can ignore your expressions of unwillingness or other absence of consent. This applies to role playing, rape play, consensual non-consent, or even MS or other authority transfer interactions. You have to name the specific forms and extent of force, restraint, or threats that are permitted, which means you have to understand the risks involved so you can decide what level you want, like marks versus no marks, or this thuddy toy but not that stingy toy, hands but no paddles, or paddles but no canes. And finally, you have to stipulate the specific words or gestures that will withdraw permission. This is our safe word or safe signal codified in the Model Penal Code. So let's look at some illustrations. Before a date, the accused sends the complainant a text saying, "Are you into BDSM?" The complainant responds, "Maybe tonight." In this illustration, the accused greets the complainant at the door, slaps them, and carries them into the bedroom where they bind them, attach clamps to their nipples, and warns them not to scream. Then they penetrate them. Is this explicit prior permission? No, this is not explicit prior permission because none of those specific behaviors were discussed and agreed to prior to beginning. They also hadn't agreed to a word or gesture that would stop what was happening. In our next illustration, at the accused's apartment, the complainant sees a BDSM magazine and skims through it with apparent interest, lingering over several of the photos. The accused says, "Interesting, huh?" When the complainant looks up with a smile, the accused leans on top of them and begins tearing off their clothes. Is this explicit prior permission? No, this is not explicit prior permission because the specific acts weren't discussed and a safe word or safe signal was not agreed upon. Even if the complainant had responded yes to the question, it still isn't explicit prior permission. In fact, this could qualify for charges of sexual assault by physical force or restraint under Section 213.2 of the Model Penal Code on sexual assault. In our next illustration, if a police officer negotiates a safe word and limits with a detainee and then they play together, that is not consensual and is considered sexual assault under the new Model Penal Code because the bottom in this situation is in a condition of legally restricted liberty. Illustration 5 discusses a local sheriff going to a party where the sheriff meets someone. They go to the bottom's home and negotiate a BDSM scene, including a safe word, and agree that the bottom could say stop and have it ignored. This is consensual under the new Model Penal Code on sexual assault. Merely being a law enforcement officer does not preclude consent, and officers can engage in personal relationships, sex, and play when they are not on duty. I hope that explains some of this more clearly. Now let's talk about Lawrence v. Texas. Lawrence v. Texas, which overturned the sodomy laws and is cited in the Model Penal Code on sexual assault, holds that adults have a constitutionally protected privacy and autonomy right to engage in mutually consensual sexual activities, as long as the person giving permission does it personally and is a competent adult, and as long as the force used poses no risk of serious injury or harm to others. Respect for individual autonomy requires deference to these choices. Now, on to why the NCSL helped make this change. This new legal framework was developed to deal with the old saying that you must have heard, consent is not a defense to assault. That's because there's not a single appellate court decision anywhere in this country that has accepted consent as a defense in an assault or abuse prosecution arising from BDSM conduct. These court cases include relatively mild activities like using a riding crop or dripping hot wax. An appellate case is a criminal case that has been appealed. And appellate cases set case law, which is different from legislation that's passed by state legislatures. This is NCSF's legal database of consent cases involving BDSM. This kind of criminalization feeds the stigma and discrimination against kinky people and our gathering places. In fact, decriminalizing BDSM was deemed the most critical issues our communities faced when consent counts was created in 2006 by the Leather Caucus at NGLTF's Creating Change. Soon after that, NCSF took responsibility for consent counts. Let's talk further about the stigma associated with criminalization. Decriminalizing BDSM will have a huge impact on the daily lives of kinky people because stigma leads to discrimination. We are also seeing more data that indicates that the stigma of being sick or violent leads to shame and guilt, which may be associated with suicide ideation. When you look at NCSF's consent surveys, they found between 80 and 90% of kinky respondents are closeted to family and coworkers. 20% are closeted to their partners. It's even worse for the millions of people who haven't accessed educational groups and don't identify as kinky. It's just how they have sex. They don't have access to consent and skills education, nor do they have access to our groups and community members who could help destigmatize their desires and teach them how to talk about sex. Debbie Herbenick's prevalence survey, Sexual Diversity in America, found that up to 30% of adults engage in BDSM activities, but less than 4% reported attending an educational workshop. The stigma and criminalization of BDSM also leads to barriers to reporting crimes committed in a BDSM context. In the NCSF Consent Violation Survey of 2015, out of over 1,000 people who reported non-consensual experiences, less than 3% said that they reported it to the police. If the legal system can better accommodate BDSM-related cases through the Model Penal Code on sexual assault, one of the major barriers to reporting will be reduced. A little history about consent counts. In order to deal with the criminalization of BDSM and its associated stigma, consent counts was started by the Leather Caucus at NGLTF's Creating Change in 2006. They decided criminalization was the #1 problem we faced as kinky folks because of the issues caused by stigma. The Consent Counts project is similar to what NCSF did to help depathologize BDSM by working with the American Psychiatric Association to change their diagnostic manual in 2013. One of the major contributions of the NCSF is conducting 3 consent surveys with tech reports and published articles in a growing number of journals. This includes a paper on sexual assault and kink, and we're working on one now on formal and informal reporting after a consent violation. These surveys and many community-wide consent discussions have led to the creation of resources posted on our website. Consent signs for events, Consent Month to help promote awareness, guides for groups to help create consent policies for dealing with consent violations, guides for individuals on negotiating and consent violations, and interpersonal violence versus BDSM resources for professionals. Under our education outreach project, you can also point people to the NCSF presentations that we've given at professional conferences and request a webinar for you and your group or practice. Consent counts originally wanted to assist in an appellate case where we could support consent and fight the idea that consent is not a defense to assault, so that we could overturn the old law. However, there were no more prosecutions of consensual BDSM, ironically, in part due to the fact that the NCSF educated law enforcement agencies around the country about BDSM, and the alleged domestic violence call mostly became a thing of the past. Instead, all we had were terrible cases where consent was denied by the bottom, with serious injuries like the Ed Bagley case in Missouri or the Glenn Marcus case in New York. So in 2015, Consent Counts launched a sub-project, the American Law Institute project, when the ALI began to revise the Model Penal Code on sexual assault. For context, the ALI is a research and advocacy group of judges, lawyers, and legal scholars that promotes the adaptation of common law to changing social needs. This is a much needed update from the last code that was created in 1962 by the ALI. The NCSF's legal counsel, Dick Cunningham, was accepted into the ALI. We were able to contribute to the clarification and modernizing of the Model Penal Code on sexual assault and include a framework for consent for BDSM activities. The new Model Penal Code on sexual assault was approved by the entire ALI membership, and the text of 21310, which I went over in the beginning, is posted on our consent counts page, along with commentary that mentions NCSF's part in creating Section 10. One very important point: the text has to be approved by each state legislature to become law. However, the text of this Model Penal Code can be introduced into any criminal court case or cited in briefs at any time. That means it will be considered by law enforcement and judges. NCSF's incident reporting and response has already submitted it in a case where both people say it was consensual and they did the right things by having a safe word and planning out what they would do. I'm going to share a video with you from the ALI. Aaron E. Murphy of NYU Law, an associate reporter for Model Penal Code, sexual assault and related offenses, provides background and a short description. It is joyous to hear such a serious scholar use our language when explaining the law.
We have provisions, lastly, that are related to kind of defenses and the ancillary issues. So point 10 puts forward what you might think of as the bondage defense or BDSM defense. It's basically a defense for the use of force in a consensual manner. This is a provision that's engendered some controversy as well. It's increasingly an issue. And this is meant to protect the sexual liberties of people who want to engage in this kind of non issues. So point 10 puts forward what you might think of as the bondage defense or BDSM defense. It's basically a defense for the use of force in a consensual manner. This is a provision that's engendered some controversy as well. It's increasingly an issue. And this is meant to protect the sexual liberties of people who want to engage in this kind of non-serious bodily injury sex play, while also safeguarding those people against exploitation and harm, and safeguarding people who don't want to engage in that behavior from a claim that they did in fact consent. And so it heightens the requirement for consent when it requires specific consent to specific acts of force or violence, and precludes force or violence that is that causes serious bodily injury. And so we had input from representatives of the BDSM community who, first of all, were very welcoming of a provision like this to protect their membership, because there is a sense that their membership is preyed upon at times by people who want to engage in non-consensual encounters and don't respect the boundaries of the relationship that are laid out, and that there's no recourse, because once a legal actor like a prosecutor finds out this person engages in BDSM, they're like, forget it, I'm never going to prove my case. And so giving greater structure to what is a legal versus impermissible sexual encounter involving violence and threats of violence. And then also providing a structure that the community itself is very accepting of, which is an affirmative consent structure. This is a community that does have norms of kind of sex positive articulation of what they are and are not going to engage in and do. And so to say, here's the safe word that we're going to use so that you know when I really want the boundary to be drawn, or here's the kind of violence I accept and here's what I won't accept, that kind of protection when that communication has taken place.
Now, I do want to mention that along with the definition of consent to BDSM, there is also a definition of consent for sexual contact without any use of force or restraint, approved in 2016, the year after the NCSF's attorney, Dick Cunningham, joined the ALI. This definition of consent is critical because in 20 states, there is no definition of consent in the sexual assault law. However, For the majority of states, this definition does reflect the legal standard of consent that is currently used. First, consent means a person's willingness to engage in a specific act of sexual penetration, oral sex, or sexual contact. Consent may be express or it may be inferred from behavior, both action and inaction, in the context of all of the circumstances. Neither verbal nor physical resistance is required to establish that consent is lacking, but their absence may be considered in the context of all of the circumstances in determining the issue of consent. Consent is ineffective when given by a person incompetent to consent or under circumstances precluding the free exercise of consent. Consent may be revoked or withdrawn anytime before or during the act of sexual penetration, oral sex, or sexual contact. So as you can see here, the general definition of consent for sex is not affirmative because it says consent may be expressed or it may be inferred from behavior, both action and inaction in the context of all of the circumstances. It also says that neither verbal nor physical resistance is required to establish that consent is lacking, but their absence may be considered in the context of all of the circumstances. This is talking about body language, and context is things like whether or not you've had sex with someone before or if this is your first time together. So the general definition of consent for sex is not affirmative consent. When we compare that definition of consent to the new Model Penal Code Section 10, affirmative defense of explicit prior permission, you need explicit prior agreement to do specific BDSM activities. That consent needs to be risk aware and informed, not just I'm game for anything. And you need a safe word. This conforms to many of the current consent standards found in the kink communities. Some communities of Leathermen do use a more implied before denied consent model in their spaces, which may include sexual touching. But the NCSF encourages them to post signs about their consent culture so people can consent prior to entering that space. Consent Counts is now educating the kink communities about the new Model Penal Code. We'll also educate our allies, such as victim advocacy agencies, state coalitions against sexual assault, LGBTQIA, and sex worker advocacy organizations. We will also educate the legal community, defense attorneys, prosecutors, and investigators, that Section 10 supports those who get explicit prior permission and equips prosecution for when someone doesn't or when serious injury is done. This will lay the ground to lobbying state legislatures to adopt the Model Penal Code on sexual assault. We will be beginning that effort with Maryland and Washington State and possibly New York. So to sum up, under Article 213, the sexual assault law, we have Section 10, affirmative defense of explicit prior permission. You may personally give another person explicit prior permission to use or threaten to use physical force or restraint, or to inflict or threaten to inflict any harm in connection with an act of sexual penetration, oral sex, or sexual contact. Whatever is done, it can't cause serious injury. Like we discussed before, this provision where you can give another person explicit prior permission may not cover edge play that results in serious nerve damage or impairment of a limb or organ. Based on this new legal framework, NCSF has updated and created new resources for groups that you can share with others. Best practices for consent to kink. All activities must receive prior consent explicitly by verbal or written agreement rather than through gestures, body language, or past behavior. An informed consent requires a discussion of the risks involved in the activity and the steps that are needed to reduce those risks, including study, training, technique, and practice. Best practices for consensual non-monogamy. Do you feel you have an equal say in deciding your relationship agreements with each of your partners? Do you feel you have enough information to understand and to agree to any potential risks involved and inform each other about any changes? Sample consent policies and procedures. This document outlines options and sets expectations for members experiencing consent issues inside and outside of events, with procedures for how consent reports will be dealt with, so everyone is on the same page. This consent policy and procedure can be adjusted for your group's consent culture and structure. And finally, the outing guide. This document can also be adjusted by your group to deal with outing and define it for members and set expectations around what is allowed with sharing information about someone. We need your help to spread the word. Tell people to contact the NCSF if they're having a criminal issue, so we can consult with their attorney and/or the prosecutor or investigator. Contact the NCSF if your group doesn't have a consent policy or procedure to deal with consent violations. Contact the NCSF if your group would like to provide education to your members about consent, BDSM, and the law. Please refer people to our main email address at ncsffreedom@ncsffreedom.org. Ways to support the NCSF. You can join the NCSF and be a part of the fight to advance equal rights for consenting adults who engage in alternative sexual and relationship expressions. There are several membership options to choose from. You can donate to the NCSF Advocacy Group, which is a 501c4, to directly help people, groups, and businesses who are facing discrimination and prosecution. Or make a tax-deductible donation to the Institute for 21st Century Relationships, the NCSF Foundation, which is a 501c3, and help educate about kink and non-monogamy and support our kink-aware professionals' free referral listing. You can volunteer for the NCSF. Raise your hand and be part of the solution. Consider donating one of your most important assets, your time. There are important tasks to be done, and we need your help to make it all happen. Commit to as much or as little as you'd like, but please make a decision today to help make a difference. You can visit ncsffreedom.org for more information. Thank you for being interested in the new Model Penal Code on sexual assault and helping keep communities safer. NCSF would like to extend our most sincere gratitude to Dick Cunningham for his time, resources, and professional commitment. And thank you to all the Consent Counts Committee, directors, and volunteers who have helped us make this change in the Model Penal Code.